So I am a healthcare attorney, and I'm here to talk today about legal issues for women in medicine throughout their careers. But before I do that, I want to say that I am delighted to be here. And my connection with AMWA began about a year and a half ago, and I just have enjoyed the camaraderie and the warm and welcome that I've received. And I've met a lot of you at my booth over the last few days, and that has just been my honor to interact with you. And I want to take this opportunity to thank Farzana and Eliza. My mom met them last year at a conference in Philadelphia, and she passed away in August, and they sent me lovely condolences on all your behalf, so I want to thank you for that. So I was a scientist before I was a lawyer. I graduated from Penn State with a science degree, and I went to Temple Law School at night while I worked in the lab during the day. And so that meant I was dissecting cow eyes at Wills Eye Hospital in the research department, doing assays to pull off the retinas and various compounds, and killing mice and using radioisotopes. So I was in a hospital setting, and that really gave me a sense of medicine having been there. Although I wasn't practicing medicine, I was in basic research. After I left law school, I went to Washington, D.C. to work in a healthcare regulatory firm, and I did FDA work, then came back to Philadelphia and worked at a biotech company called Centocor in the regulatory affairs department, drafting consents for research. So I have a bit of a sciencey background. I then started as a healthcare attorney in about 1989. And that was before there really was a healthcare attorney. I mean, we're really a relatively new profession in law. And I'll say we're a subspecialty, but in a sense, we don't go to law school for a subspecialty, we don't have a fellowship or anything of that sort, but we really do have unique issues to the healthcare environment. And we're going to talk about some of those today. Can I have the second slide, please? Thank you. So who are healthcare attorneys and what do they do? So we're business and regulatory lawyers. And what I do is I negotiate and help my clients navigate through transactions, regulatory issues, and compliance issues for their practices. And these are issues that happen within the practice, so maybe a shareholders agreement or employing other physicians to protect the practice, or outside the practice with third parties. I'm never involved in any malpractice suits. I never go to court. And I really would probably be terrified if I had to walk into a courtroom. Next slide, please. So before we can talk about sort of the issues, we have to think about what are the sort of types of transactions and things that you might be confronted with. And so we have a very diverse audience here today. And pardon the glasses on and off, that is a 50s thing. I can't see anything and then I can see everything. So there's essentially three environments where you may end up practicing. So it would be either an academic environment, a hospital or health system, or a private practice. And in an academic environment, and you'll see across them, there are commonalities in terms of the types of things and issues and transactions that are going to arise. So each one you're going to have potentially an employment agreement. So for the young physicians, it'll be your first employment agreement out of residency or fellowship. For more senior doctors, it may be moving from one academic environment to another. Clinical research agreements, I do negotiate those. Anybody involved in clinical research would have a principal investigator agreement, and you'll be signing those. There is liability there, just as an aside. You may have consulting agreements, and there's always going to be compliance matters, because embedded in the practice of medicine is the concept of compliance. And that really is documentation and coding. And I tell all young physicians that that's something that you really need to get yourself educated in And again, we could talk a whole day on documentation and coding. If you're in the hospital or health system environment, again, you'll have that employment agreement. You may have a restrictive covenant. You may want to leave that hospital or health system and go to another hospital or health system, and then how do you do that in the context of the restriction that's on you? And we'll talk a little bit about restrictive covenants as well. Clinical research agreements, again, I negotiate those. That's my only hospital client, is a hospital affiliate that does cardiac research, and I negotiate all the clinical research agreements for the cardiology research that they do. And that's usually with pharmaceutical companies and medical device manufacturers. You may have a consulting agreement, something you do outside of your practice, maybe with the approval of the hospital or health system. And then again, yet again, I will say this probably too many times, compliance matters. Because you will be audited and you will have to be scored on your compliance, and that'll be for your documentation and coding. Now, if you're in private practice, again, we're sort of still trying to get the universe of types of matters that you would see. You'll have that employment agreement, that first employment agreement. I usually help negotiate those when you're coming into a practice. After a few years, you would then become potentially a shareholder or a member of what we call a limited liability company. There's different entities, but they're essentially the same thing. That's your ownership document, it's your buy-in, it's your payout, those kinds of things. And then there'll be third-party contracts. Those will be similar to academic and hospital and health system, but a little bit different because now you might have a group contract, right? So you might have a good-sized group of physicians, and then you'll be negotiating that agreement with your payers to try to get maybe a better rate, depending on the size of your group, and because better rates means better compensation, right? And then again, compliance matters. What a surprise. Next slide, please. So in terms of the universe of issues and matters, we would look at the ones that are common. I was trying to find a way to talk to so many diverse physicians at so many different stages of their careers about commonality of issues that come up regardless of the type of transaction or matter that we're dealing with. So we will have all of these things, as I said, in each one. Compliance. There'll be business issues. There'll be legal issues. There'll be issues related to what happens upon termination of that arrangement. But the first that always needs to be addressed is the federal and state law or any other applicable law, and I'll call that the lawfulness. Next slide, please. So you're in a highly regulated industry. Oil and gas, securities has nothing on you. You are, most physicians, although we heard from somebody who is a concierge physician, and there may be some still in the audience today, most physicians take Medicare and participate with Medicare and typically other payers. And that makes you part of the regulated industry because you're taking federal dollars as reimbursement for your service. And so when we're doing an analysis of the lawfulness, we would look at the goods and services that are provided, the compensation to be paid, and you'll hear me use the term fair market value. That's, I go to seminars that are day-long on fair market value, if you could believe that. And yet again, billing, coding, and documentation. So let's digress briefly and talk about the laws. So the principal federal law, there's two of them, but the one that came first was the anti-kickback law. And that law says that a physician may not get anything in exchange for the referral of Medicare or Medicaid patients. So that can mean anything from sort of the obvious, which is someone paying you to refer the patient to them, to the not so obvious, like a medical device company deciding to rent a closet in your practice. And believe it or not, there are Office of Inspector General opinions on each one of these things. And there are regulations that are yay thick that healthcare lawyers have had to read. And so the anti-kickback law is foremost in our mind when we're looking at an arrangement or transaction. Typically with an employment agreement, you're not going to run into that too much if you're going with a hospital or health system, because they've done their homework to make sure that what they're paying you is fair market value. At the same time, they also use that against you, right? So they'll claim something isn't fair market value, and then that's where we need to do our due diligence on the back end. So the next law that's important that you need to hear, and some of you students for the first time, is the Stark Law. And the Stark Law is the law that says a physician may not refer a Medicare or Medicaid patient to an entity with which the physician has a financial relationship for designated health services without meeting one of the Stark Law exceptions. So what are the designated health services? They're lab, radiology, physical therapy, parenteral enteral nutrients and supplies. And again, the exceptions are numerous, but we're always looking to try to fit you all into some exception as best as we can. Here's the thing about the Stark Law. I call it the long arm of the Stark Law. It reaches into the middle of your practice, if you're in private practice, and it dictates how you can distribute money for any of those ancillary services that I mentioned. Okay, so I have a client that's a large urology practice. They have an IMRT center. We are in the midst of machinations and trying to do every combination permutation to get them to fit into a certain category so that they can distribute IMRT money in a certain fashion. And surprise, surprise, the doctors who are the bigger referrers to the IMRT center want to somehow get a bigger piece of that IMRT dollar pie. So again, these are part of the issues that we deal with as healthcare lawyers, and that's the Stark Law. And of course, we all know HIPAA. We can't get away from HIPAA. And there's federal employment law types of issues. There's state laws. A lot of the states, most states, have some sort of mini Stark or mini anti-kickback. Then there's licensure requirements and licensure laws if you're going to set up an ambulatory surgery center, or you're purchasing an ownership in an ambulatory surgery center, or you want to structure your practice to have what we call them ASCs as part of your practice. Sometimes physicians do that because you can get some greater reimbursement by being an ASC. And then there's employment laws. In medical practices, as well as in hospitals, health systems, there's always employment laws. You've got someone who's leaving, there's wage payment laws, and of course, other compliance issues for, say it all, documentation and coding. The next slide, please. So any matter that you're dealing with is going to break down into business issues and legal issues, right? So we've talked about lawfulness. The business issues are, for example, in an employment agreement. What's your compensation? Does it make sense? Are you getting a sign-on bonus? For the young doctors, are you working for a nonprofit and possibly getting some repayment of your loan dollars? That can be a big help. From hospitals and health systems will do that, and I try to help doctors negotiate that. Things along those lines. If it's an ambulatory surgery center ownership interest, let's say you're in ophthalmology or any other specialty that uses that as an extension of your office, you may want to go ahead and so you need to figure out what the profit margin is going to be by virtue of what it is that you're buying in. And then there's the legal issues. And when I say legal issues, I'm really talking about liability. Okay, what kind of liability are you as an individual taking on in connection with that arrangement? And that goes across any type of matter that we're dealing with, whether it be an employment arrangement, a service contract, a lease, an EMR, or a compliance matter where a payer's asked for money back. It really doesn't matter. We're going to deal with that issue in each of those situations. And So when we talk about liability, what are we talking about? Well, contractually, we may be talking about what the past acts of that entity are, or of you, in connection with that arrangement, or the future acts. So, for example, with a physician signing on to a new employment agreement, it's the end of your employment agreement, and who's responsible for the tail? So I'll digress, because a few people have asked me what tail coverage is over the course of the last few days. And there's basically two types of malpractice insurance. There's occurrence and claims made. Occurrence is the good one, and it basically is the more expensive, and it means that you'll be covered to the end of time. Lawyers use that phrase, from the beginning of the world to the end of time, for any claims that come up in connection with that particular policy when you were under that policy. Claims made does not have the same sort of broad coverage, so when you're finished that employment or that arrangement, you need to go out and buy what we call an extended reporting endorsement to allow you to continue to report a claim and extend that reporting period, and we call that shorthand for a tail. So who's responsible for the tail? In many states, including Pennsylvania, failure to purchase a tail could be loss of licensure. It's on the doctor. If it's not included in your employment agreement as something as who's going to pay it, then you're going to be liable for it. And it's crazy, because the malpractice tails typically run anywhere from 1% to 200% of what the annual premium is. So for obstetrics and gynecology, that could be, I've seen $40,000 to $80,000. For somebody who's been a cardiothoracic surgeon for a few years and they've been under a tail policy and they're leaving a hospital or health system and it wasn't clear under that contract who was responsible, you can imagine how high that might go. Let's see, I think I'm losing my place. Next slide, please. So let's talk about the typical arrangement, all right? A service contract, whether it be an employment agreement, a medical director agreement, could be a medical director at a nursing home. The first thing we're going to look at in terms of some of the issues are the scope of the services. So the extent of the services, how often you're going to be there. I have physicians who come to me and say, okay, I don't want to work full-time. They've agreed that I could be what we call a 0.8 full-time equivalent. I'm going to work 4 days, but I am probably going to take a full-time call. And what we want to make sure that whatever's been promised to you as the job is ultimately included in your contract, because you would be surprised at how often those things don't jive. And typically, again, here's my physician bias, because I'm always on the front lines for you guys, they're hard-pressed to say no at that point, right? That they promised you something, whether it be tail coverage, whether it be, X number of days and no nights. Again, you go to the lifestyle issues and the things that are important to you, and I think you would be surprised at how often we're successful at getting some of the things that we want. We don't get everything, but we always ask for more than we want so that we get enough. Compensation. So we've been talking a lot about compensation throughout this conference for days, and it is absolutely a crime to me that women physicians are not paid equal to men. It enrages me. And I do deal with compensation issues constantly, because I don't know how you can review a physician employment agreement anymore without understanding the compensation methodology. Compensation is now this complex animal that is typically based in some sense on work relative value units. So for those of you out there that don't know what a work RVU is, this is your first introduction, and if you were at my exhibit table, maybe you picked up a copy of my article that's going to be on the AMWA website that explains in one of the footnotes what a work relative value unit is. But in any event, it is assigned by the Centers for Medicare and Medicaid Services. Every service you provide has a code, and every code has a work relative value. So in a physician employment agreement or a service contract, you would get potentially a base compensation. At the end of the year, all your work relative value units are added up, and then someone decides you either made your level that you were supposed to make, in which case you might actually get a reduction, hate those, or you may get a productivity bonus at a dollar value per work RVU over and above, for all the work RVUs you did over and above your threshold. So you can see that these are kind of Rube Goldberg machines, right? We're constantly like adjusting work RVU value, what's the threshold. I'm negotiating for some gastroenterologists now who have a practice, and they're going to a health system, and this is part of the conversation. And again, we could talk a whole day on physician compensation, work relative value units. There are conferences where the hospital MBAs get together and this is discussed. Compensation is one of those areas that it's really important to do a cogent analysis. And what do I mean by that? So when someone comes to me with an employment agreement, and I look at that employment agreement and I do the analysis, what's the first thing I do? I look at benchmarks. I look at comparables. I look at the Medical Group Management Association survey numbers to sort of say, okay, somebody coming out of a program or somebody this many years out, what is the national average of compensation that the physician should be entitled to, and what are the corresponding work RVUs and or collections that are associated with that? That's accessible. And that's something I think over the course of the next year, I'm hoping we can work with AMWA to make something like that accessible to you so you can know where you're falling. I mean, you know, the thing that I see often, again, here's that physician bias, is hospitals and health systems will ask you to perform at the 75th percentile of work RVUs, but they'll only be offering to pay you at the 45th percentile. What's wrong with that picture, right? So the other thing that we always want to look at is term and termination of a contract. Pretty much any contract, we're always looking at what the term and termination. If someone says to me, I've got an emergency today, what happens with this contract? The first thing I do is look at the term and termination clause, okay? And for the young physicians, they're going to say to you that we're offering you a 3-year term, for example. And then when you dig into the contract, guess what? Either party can terminate that contract on 60, 90, 120 days notice. What do you have? 60, 90, or 120-day term, right? It's not really 3 years. It kind of looks like a duck and it quacks like a duck, but it's not really a duck. There'll be restrictions that we'll look for. Non-compete. For those of you that don't know what that is, it's a restriction on where you may practice after termination or during the term of the contract, which usually is not a problem, or after termination for some period of time. It's often a mileage radius, and it's as the crow flies. So freemaptools.com, I tell all my clients, and you can map it out, and it may be from every location where that practice or hospital or facility has a location. I always try to say it's from the location where you're principally rendering services. So we try to narrow it. We're narrowing your liability. We're narrowing the types of things that you could be subject to. And we talked about tail coverage and whether or not that has to be paid by you or by the employer, hospital, health system, group practice. Or whether or not, for example, you have to pay back your sign-on bonus and your moving expenses. Happens all the time. If you don't stay in that contract for the full 3-year term with a hospital or health system, you got to pay the full amount of the sign-on bonus back. But guess what? That's after-tax dollars. And when you got it, you probably got it after taxes. So you're paying back more than you got, number one. Number two, what if they can terminate you on 30, 60, or 90 days notice, in which case, wow, they could terminate you and you'd be obligated to pay the money back. That's not right. I usually win that point, I have to say. That is a consistent winner across the board. It's like, how can you ask this person if you just terminate them without cause? Liability issues, again, compliance, documentation and coding, what a surprise. You would not believe what I've seen in physician employment agreements for hospitals, where they can take back dollar for dollar from the doctor if a payer asks for the money back. It's outrageous. They should be doing that. They should be checking your coding and your documentation. It's their responsibility. It shouldn't be on you. It's not like you're making the upside of this arrangement, right? You're not getting the profit associated with it. And then indemnification. So that's a sophisticated legal concept, probably too heady for a Sunday morning after a late night with some alcohol. But it basically means that one party is agreeing to pay the legal fees of the other party if the other party incurs them because of something I do. Okay, so if I indemnify Farzana, I'm basically saying, Farzana, if you incur a legal cost or any other expense because of something Karen Davidson did, I'll pay your legal bill. But guess what? You don't have insurance for that. It's not part of your malpractice insurance. So message today, don't sign indemnifications without getting your lawyer to look at it. Next slide, please. So just briefly, we've got ownership interests if you're purchasing an ownership in a facility, and there's legal issues, and again, the same legal issues, business issues. You may be buying assets or you may be buying stock. And then next slide, please. Develop a strategy, all right? Develop a strategy for every transaction or matter you're going to be part of. Get the lay of the land of that particular matter and figure out what your goals and objectives are. And then figure out how to navigate through the process. Next slide, please. We covered, is it lawful? You're developing a strategy in terms of what is it that I want from this deal or arrangement? Do I want to buy an EMR system? Do I want to work at this hospital system? You evaluate your negotiating position. How strong is it? Most young doctors come to me, the young ones, and say, oh, I don't really think I can ask for anything. You'd be surprised. And I know you had a negotiation session on the Thursday before, when I was at the farm, by the way. And, you know, you'd be surprised. We don't want to ask for too much. It's that fine balance, art, not a science. Who you're dealing with? Is there a CFO or a lawyer or a contracting person? Are you a hospital employed physician that's been marched into a room with the 3 other business people and it's kind of just you sitting there and you're like majorly outgunned and you haven't had a chance to prepare and someone hands you a piece of paper to sign? Buy yourself some time. And where is your attorney? So as legal counsel, I work with clients in just a variety of ways because every client's different. There's no cookie cutter approach. Some people are way more comfortable being on the front lines. They just say, nope, I got it. You know, Davidson, you got me, you know, I put you back into the ring. We talked about the issues, we talked about the liability. Usually if you're dealing with a hospital or health system and we're talking about things like indemnification, maybe I can help you manage the legal bill, right? And then you go off and you negotiate the business terms and I go off and negotiate the legal terms or I feed you a document that's what we call blacklined and it shows the markup and then you take it off. Some people have me write their emails for them. And so I'm behind the scenes or in front of the scenes. It's everybody's personality. It's however it works. Next slide, please. So once you get to sort of all of that, the lawfulness, the negotiation, figuring out your strategy, how you're going to move these chess pieces. And this is a chess game and it's a poker game. You hold your cards close to the vest. You know, again, these are negotiation techniques and we could talk for an entire morning about those things. You end up negotiating the deal. If you're giving confidential information to negotiate in connection with selling your practice to a hospital or health system, there needs to be a confidentiality agreement. They should only be able to use it for one purpose. Whatever deal you're doing, I like the idea of getting the major terms somehow in writing, whether it be a letter of intent or whether it just be an email or, new doctors will get that offer letter. And we'll get to the liability issues when we finally get the contracts and sort of see. But that's one area that it really helps if you've got two deals to compare it to, right? If you're looking at jobs and you narrow it down and say, okay, I've got this one employment agreement, this is where I really want to go, I encourage you to have two. So I was a beekeeper for a while. I'm a farmer wannabe. And my mentor beekeepers would always say to me, have two hives, because you have to be able to compare and contrast them to each other, because you don't know how well the queen's doing. In fact, I had a bad queen, so that's a separate story. But if you have two deals, if they're similar in compensation, maybe one is more, maybe one is less, maybe the one that's less doesn't have a restrictive covenant, or the restrictive covenant is going to be something that's easier to negotiate. And then the contract termination issues. How can you get out? I had a young doctor who I negotiated a recruitment deal, which is a more complex type of employment arrangement where a hospital or health system gives a medical practice some additional dollars to support having that new physician. And that's lawful under certain circumstances. And we negotiated for her a whole variety of terms, which she really didn't understand at first, what I was doing, because it was she had so much liability that we were trying to mitigate. But in the end, how could she get out of that contract? And the other people that signed that contract as is, not her, are now stuck there for 6 years to pay off and not have to pay hundreds of thousands of dollars that was advanced. Next slide, please. So I will leave you with, just conceptually, hopefully I've imparted some knowledge. And what I said to somebody when I got to the conference the other day was, they said, oh, you know, everybody seems to be having a lot of questions. And my comment was, in part, that what concerned me was there wasn't enough knowledge to know what questions to ask. And so I'm hoping that I've laid the groundwork and put out the seeds of some information and knowledge, and I hope to work with AMWA this year to have some webinars or things that will maybe elaborate on some of these issues, or for people that haven't been able to attend. And thank you so much. Next slide, please. And I'll take any questions if you'd like.